Namaskar, brothers and sisters, ladies and gentlemen, students and scholars, teachers and trainers, professors, professionals, officials, listener learners. I welcome all respected doctors and directors. I welcome all honorable ministers and managers. I welcome all honorable advocates, notaries and administrative advisors. I welcome the most honorable President Mr. Modi ji, all my dear friends, those who are listening, watching YouTube channel 3M Creator. I heartily cordially welcome all my dear friends. As you know that it is the last day of this year. Tomorrow will be the new year and we will celebrate new year with new thoughts, new ideas, new energy, with having the high attitude for the betterment, upliftment of our nation. We forget all our falsifications, narrownesses, infirmities, shortcomings, drawbacks, and we enter the new world with a great hope, thoughts, ideas, expectations for the future. It happens every year with the change of the time. There we see the great change in the nation. The natural changes takes us towards the relaxations and that becomes our great achievement of that time. Our holy Indian constitution, our holy Indian culture address the message of unity, oneness and equality. On this basis, we study and we create, generate, operate new relationships with the world. What is the influence of national law? The origin of national law can be traced to centuries. The origin of national law can be traced to centuries before the birth of Christ. Probably no other principle or school of law took as much time in its development as the law of nature. Moreover, as the key remarked by Dice, no other phenomenon of legal or political theory is so visual with stars as that of national law. However, it has engaged the attention of some of the greatest thinkers of all ages. Credit of giving birth to natural law must go to the Greeks. After the Greeks, Romans further developed it. The early and original law of Romance was called jus civile. Later on, they developed another legal system called jus gentium. It was called jus gentium because it was thought to be the law of universal application. In the Republic era of Rome, jus gentium was reinforced by natural law or jus naturale as was commonly called. By jus natural, the Romans meant, as pointed out by briefly, the sum of those principles which ought to control human conduct because founded in the very nature of man as a rational and social being. The law of nature is the expression of what is just against, what is merely expedient at a particular time and place. It is what is reasonable against what is arbitrary, what is natural against what is convenient, and what is for the social good against the personal will. Thus, natural law was based on the rational and reasonable needs of man the nation. Most of the jurists admit that natural law greatly influenced international law and gave it its binding force. The writers and jurists of the Middle Age developed law of nature in accordance with the values and conventions of their age. In this period, natural law was linked with religion. For example, according to St. Thomas Aquinas, natural law is a part of the law of God which man seeks through his reason. Roman law in Europe in 16th century contributed much in the beginning in the development of modern international law. It will be desirable here to refer briefly to the criticism of medieval conception of natural law. In this period, it was believed that there existed rationally in the universe. Besides being an exaggeration, the belief in this conception was not substantiated by the practice of the states. Secondly, according to the writers of the medieval age, If there was a conflict between positive law and natural law, the latter would prevail. It was a very revolutionary idea and could not be accepted. Despite this criticism, it must be admitted that national law emphasized an importance of purpose behind law. It stressed that law was not a body of meaningless rules or principles to be enforced by the courts. In fact, law existed to achieve definite objectives. In 18th and 19th centuries, the positivists were in vogue. The positivism was based on the actual practice of states. It was a period of decline of the natural law. The positivists denied the existence of any purpose behind the law. According to the positivists, people would be bound to obey law if it was created by appropriate legislative authority or sovereign, irrespective of its being reasonable or unreasonable. They called this law positivum or positive law. For example, the law in fact, this in the thus in the view of thus in the view of the positivist in the conflict of the positive law and natural law, the former will prevail. 20th century saw the revival of the natural law. Positivism was subjected to severe criticism once against faith in natural law was reaffirmed. However, the conception of natural law underwent significant changes in this period, basing their views on Kant and Hegel. The modern writers adopted natural law in accordance, accordance with times and circumstances. The chief exponents of this movement were Stanier and Kohler. For example, Stanier Stanier admitted that natural law could be adopted to the changing times and circumstances, although its fundamental principles remain unchangeable. He therefore propounded the theory of natural law, with with a variable content. In the recent times, Professor Fuller of America has emerged as great exponent of natural law. He has propounded the theory of inner morality of law. In other words, there is an inner morality of law and there is a definite purpose behind law. Law is not a body of meaningless rules and does not exist for its own sake. Law exists or is created to achieve some purpose. The concept of natural law developed from time to time, how deeply influenced the growth of international law. In the words of Sir Henry Maine, the great The grandest function of the law of nature was discharged in giving birth to modern international law. Stark has also remarked traces of natural law theories survive today, albeit in a much less dogmatic form. There are many traces of the influence of natural law on international law. For example, the development of human rights, system of punishment of war crimes, etc., are all due to the influence of natural law. Thus, the idealist character natural law has greatly influenced the international law. It may, however, be noted that natural law kept itself aloof from the actual practice of states. This was the main defect of natural law. It was this reason that was responsible for the decline of natural law. नए साल का जश्न मनाए लेकिन संभल के जश्न के नाम पर हुड़दंग सावधान इंदौर की भागलपुर इलाके का मामला सुरक्षा के लिए शहर शहर मुस्तैद है पुलिस बीमारों में उल्टी दस्त नए दिल्ली में नए साल का जश्न ड्रोन से निगरानी सीसीटीवी पर भी नजर दूषित पानी पीने से 3 की मौत इंदौर में नए साल का जश्न मनाए लेकिन सावधानी से जल के नाम पर हुड़दंग जश्न के नाम पर हुड़दंग सावधान बीमारों में उल्टी दस्त डिहाइड्रेशन के लक्षण मृतकों के परिजनों को 2 लाख रुपए की मदद मिलेगी इंदौर में दूषित पानी पीने से 3 की मौत दिल्ली में नए साल पर सुरक्षा के सख्त इंतजाम ड्रोन से निगरानी सीसीटीवी से भी नजर दूषित पानी से होने लगी बीमारियां इंदौर में जल के जश्न के नाम पर हुड़दंग सावधान Let us go towards sources of international law, formal and material sources. As pointed out by Stark, the material sources of international law may be defined as the actual materials from which an international lawyer determines the rule applicable to a given situation. The term source refers to methods or procedure by which international law is created. A distinction is made between the formal sources and material sources of law. As pointed out by Z. Fismuris, they may also be described as respectively as direct and indirect, and approximate or immediate, and remote or ultimate. Material sources may also be described the origins of law, while the material, historical or indirect sources represent the stuff out of which the law is made. That is to say, they go to the form they go to the form, the content of the law. The formal, legal and direct sources consist of the acts or facts whereby this content is clothed with legal validity and obligatory force. The essence of the distinction, therefore, is between the thing which inspires the content of law and the thing which gives that the content its binding character as law. The formal are those legal procedures and methods for the creation of rules of general application which are legally binding on the addressees. The material sources provide evidence of the existence of rules which, when proved, have the status of legally binding rules of general application. Further, the sources of international law must not be confused with the basis of international law. This is to be found in the common consent of the international community. The sources of law, on the other hand, concern the particular rules which constitute the system and the processes by which the rules become identifiable as rules of law. The sources of the rules of law, which therefore distinct from the basis of the law, are nevertheless necessarily related to the basis of legal system as a whole. The sources of international law may be classified into five categories. One is international conventions, two is international customs, three is general principles of law recognized by civilized nations for its decisions of judicial or arbitral tribunals and justice forms, five is decisions or determinations of the organs of international institutions. The above mentioned third source, general principles of law recognized by civilized nations, was first mentioned in Article 38 of the Statute of the Permanent Court of International Justice. It was retained in Article 38 of the Statutes of the International Court of Justice, which mentions the following sources of international law. One is international conventions, two is international customs, is general principles of law recognized by civilized nations, and for its judicial decisions and the teachings of most highly qualified publicists of the various countries as substitute remains for the determination of rules of law. The mentioned fifth cause, that is decisions or determinations of the origin organs of international institution, does not find mention in Article 38 of the Statute of the Court, but it has now become a well recognized source. One is international conventions. In the modern period, international treaties are the most important source of international law. This is because the reason inter alia that states have found in this source a deliberate method by which to create binding international law. Article 38 of the Statute of the International Court of Justice lists international convention, whether general or particular, establishing rules expressly, establishing rules expressly recognized by the contesting states as the first source of international law, as pointed out by Manley O. Hudson. The term conventions is used in a general and inclusive sense. It would seem to apply to any treaty, convention, protocol, or agreement, regardless of its title or form. A convention may be general either because of the number of parties to it or because of the character of its contents. It may be particular because of the limited number of parties or because of the limited character of its subject matter. Whenever an international tribunal decides an international dispute, their its first endeavor is to find out whether there is an international treaty on the point. In case there is an international treaty, the decision of the court is based upon the provisions of that treaty. According to Article 2 of the Vienna Convention on the Law of the Treaties 1969, a treaty is an agreement where a treaty is an agreement whereby two or more states establish or seek to establish relationship between them governed by international law. But this definition is narrow and does not seem to be correct, as correctly pointed out by Professor Squargin Berzer. Treaties are agreements between subjects of international law creating a binding obligation in international law. However, it would be wrong to say that Vienna Convention does not show its witness to this fact, for Article 3 provides that the fact that the present Convention does not apply to international agreements concluded between the states and other subjects of international law or between the other subjects of international law or to international agreements not in written form shall not affect the legal force of such agreements, the application to them of any of the rules set forth in the present convention to which they would be subject under international law independently of the convention. The application of the convention to the relations of states as between themselves under international agreements as to which other subjects of international law are also parties. Vienna Convention on the Law of Treaties 1969 has 114 parties as of April 2014. Reference may be made here to Vienna Convention on the Law of Treaties between states and international organizations or between international organizations 21 March 1989. Article 1 of this convention provides that the present convention applies to treaties between one or more states or one or more international organizations and treaties between international organizations. Further, Article 6 provides that the capacity of an international organization is governed by the rules of that organization. Moreover, Article 26 of the Convention reiterates the principle of Moreover, Article 26 of this convention reiterates the principle of pacta sunt servanda. It provides that every treaty in force is binding upon the parties to it and must be performed by them in good faith. International treaties may be of the two types. One is law-making treaties and two is treaty contracts. One is law-making treaties. The provisions of law-making treaty are directly the source of international law. The development of law-making treaties received an impetus from the middle of 19th century. The main reason for this was that in view of the changing circumstances, customs, which were hitherto the most important source of international law, were proving to be inadequate. Consequently, Consequently, states regarded it necessary and expedient to enter into treaties and thereby established their relation in accordance with the changing times and circumstances. Law-making treaties may again be divided into these following types. One is treaties enunciating rules of universal international law, United Nations Charter is the best example of such type of treaty is international treaties which lay down general principles. These treaties are entered into by a large number of countries. 1958 Geneva Convention on the Law of the Sea. Vienna Convention on the Law of Treaties 1969 are good examples of such type of treaties. Law-making treaties perform the same function in the international field as legislation in the state field. Lawmaking treaties are the means through which international law can be adopted to in accordance with the changing times and circumstances and the rule of law among the states can be strengthened. Treaty process is also a useful means to develop universal international law, but an international treaty can enunciate universal principles only when it receives the support of the essential states. For example, a lawmaking treaty which does not receive the support of nations such as Russia, Britain, America, France, France, and China cannot effectively enunciate general or universal rules to its treaty contracts as compared to law-making treaties. Treaty contracts are entered into by two or more states. The provisions of such treaties are binding on the parties to the treaty. Such treaties also help the formation of international law through the operation of the principles governing the development of customary rules. This may happen when a single rule is incorporated in a number of treaty contracts. Besides this, a treaty entered into by a few states is subsequently accepted by many other states as they enter into similar treaties. Finally, a treaty may be of con- may be of considerable evidentiary value as to the existence of a rule which has which has crystallized into law by an independent process of development. What is international customs? International customs have been regarded as one of the prominent sources of international law for a long time. It is the oldest and the original source of international as well as of law in general. It is only in the modern period that the importance of customs has suffered a setback. However, even today, it is regarded as one of the important sources of international law. Customary rules of international law are the rules which have been developed in a long practices in the long process of historical development. Article 38b of the Statute of International Court of Justice recognizes international custom as evidence of general practice accepted as law as one of the sources of international law. In order to understand the man, in order to understand the meaning of custom, it is necessary to know the meaning of the word usage. The words custom and usage are often used as synonyms. In fact, there is difference between the usage and custom, and they are not synonyms. Usage is in fact the early stage of custom. By usage, we mean those habits which are often repeated by the states, as pointed out by star, where a custom begins, usage ends. Usage is an international habit which has yet not perceived the force of law, in which, in the words of Star, usage represents the twilight stage of custom. Custom begins where usage ends. Usage is an international habit of action that was yet not received full legal attestation. Usages may be inconsistent and opposed to each other, but this can never be the case with the custom. When states in their international relations start behaving in a particular way, in certain circumstances, it is expected that in a similar circumstances, they will behave in the same way. This is called the usage. But when this usage receives the general acceptance or recognition by the states in their relation with each other, there develops a conception that such a habit or behavior has become right as well as obligation of the states, and in this way, usage becomes the custom, as aptly remarked by Weiner. A custom in the intendant, a custom in the intendment of law is such usage as that obtain the force of law. It is not necessary that the usage should always precede a custom. It is also not necessary that a usage must always become a custom. In certain cases, a usage may become a custom. In certain other cases, it may not become. गंगा घाट और काशी क्षेत्र मंदिर क्षेत्र में फ्लैग मार्च के साथ शांति व्यवस्था बनाए रखने की अपील। धार्मिक स्थलों पर पर्यटकों की भारी भीड़। नए साल को लेकर सुरक्षा के पुख्ता इंतजाम। सुरक्षा मद्देनजर को लेकर पुलिस का फ्लैग मार्च। सीसीटीवी कैमरों से हो रही निगरानी। चेकिंग अभियान के दौरान जागरूकता का संदेश। एसएसपी ने चलाया चेकिंग अभियान। आगामी बजट समेत कई आर्थिक मुद्दों पर अहम बैठक। विकसित भारत का सपना अब वास्तविक जन आकांक्षा। पीएम से रामलला के प्रतिष्ठा द्वादशी में शामिल होंगे राजनाथ सिंह। खालिदा जिया के जनाजे में शामिल होंगे एस जयशंकर। जयपुर छात्रा सुसाइड केस, स्कूल की मान्यता रद्द। सरहद पर 26 जनवरी के लिए तैयारियां। आज क्विक डिलीवरी प्लेटफॉर्म सर्विस रहेगी बंद। साल के आखिरी दिन क्विक डिलीवरी नहीं मिलेगी। कई कारणों से विरोध प्रदर्शन। योगी कैबिनेट का जल्द होगा विस्तार। कल सीएम आवास पर हुई कोर कमेटी की बैठक। मंत्रिमंडल विस्तार और संगठन में बदलाव की चर्चा। जल्द हो सकता है मंत्रिमंडल विस्तार। बड़े स्तर पर संगठन में फेरबदल की भी तैयारी। फेरबदल की भी प्रक्रिया। यूपी 6 जनवरी को ड्राफ्ट लिस्ट होगी जारी। फाइनल वोटर लिस्ट 6 मार्च को होगी जारी यूपी से। आज टीएमसी डेलीगेशन आयोग। एआई के इस्तेमाल से किया जा रहा है घोटाला। और ममता से अभिषेक बनर्जी का अमित शाह पर पलटवार। भारत बना दुनिया की चौथी बड़ी अर्थव्यवस्था। तमाशा मिश्रा बनी झारखंड के डीजीपी। गुरुग्राम में नशे में ड्राइव करने पर जुर्माना। त्रिपुरा हत्याकांड को लेकर अगरतला में जोरदार प्रदर्शन। केजीएमयू के खिलाफ विरोध प्रदर्शन। स्टालिन सरकार को बड़ा झटका, राष्ट्रपति ने लौटाया वीसी। In the connection, Torsten Giegel had summarized his conclusions. In certain cases, usage gives rise to international customary law. In other cases, it does not, but there is no rule of international law, indeed any rule at all, which determines when usage shall give rise to custom, to which, together with usage as purely factual phenomena, there are a number of other purely factual phenomena: state interests, powers, factors, general opinion, historical events, etc., which in various combinations contribute to the creation of international custom, and custom can arise even without any usage. The coming into existence of a customary rule is an historical process which, in certain cases at least, can be demonstrated by purely historical methods, but there is no rule of law which determines when these factors shall give rise to international custom. When a usage is combined opino, with opinio juris since necessitatis rule of customary law exists, and it is probably justifiable to say that the usage reflects a customary rule if it is connected with a practically universal opinion juris. Thus, when a general usage in international sphere or state practice is connected with opinion juris at necessitates international customary law exists, there is a statement about effect and as such almost a tourism since the usage of this kind is a general practice accepted as law by definition or definition a custom as appointed out by the International Court of Justice in Northeast Continental Shelf basis for a state practice to constitute opinion juris not only must the acts concerned amount to a settled practice, but they must also be such or be carried in such a way as to be the evidence of a belief that this practice is rendered obligatory by the existence of a rule of law requiring it the need for such a belief, that is, the existence of a subjective element is implicit in our notion of the opinion. Jurists shall necessitate the state the states concerned must therefore feel that they are conforming to what amounts to the legal obligation for reducing for reducing the subjective element bilateral or multilateral treaties, resolution of General Assembly of the UN International Conferences and statements of state representatives, etc. may be seen. Generation Treaty of Customary Rules of International Law, a provision of RTT may also generate a rule of customary international law in North Sea continental shelf case. The International Court of Justice observed that provisions in treaties can generate customary law and levy. In the words of the court, a non-creating character in the view of the word court, the non-creating process is a perfectly possible one and does not from time to time occur. It constitutes indeed one of the recognized methods by which new rules of customary international law may be formed. According to the court, the first three articles of the Geneva Convention on the Continental Shelf 1958 are of the non-creating character, but a treaty provision can generate customary international law only when the provision concerned is of a fundamentally non-creating character, such as could be regarded as forming the basis of a general rule of law. In the present case, the court was constructing Article 6 of the Convention, which lays down equidistance principle for the demarcation of continental shelf between two coastal states. According to the court, Article 6 was not intended to be a non-creating character. One of the reasons given by the court was that the principles of equidistance was prefaced by the words in the absence of agreement. As pointed out by the writer, the word court's decision in the North Sea continental shelf cases is a major contribution to that branch of the theory of customary international law dealing with non-creation by means of RTT. The court articulated a new methodology for determining which provisions in treaties can form the basis of universally binding customary law. As the spreading network of international convention becomes more fine meshed, the substantive rules of international customary law may be expected to conform more and more closely to the provision in these conventions. The World Court has implicitly recognized this process in many prior opinions, but it was not until continental self-decision that the link between treaty and custom was forced with precision. The court thus recognizes the fact that The conclusion of our treaty is a step of international significance taken by two or more. There are definite meeting of the minds in the treaty as we infer from an act involving two or more states that constitutes practice for the purpose of customary law. But also there is the clear articulation of a rule of law that gives the treaty a special impetus towards formulating a general rule against many rules of customary international law. Perhaps even the majority had their origin in treaties, and the word court itself in several cases has used treaties for evidence of rules of law held by upon non-parties. Ingredients or elements of custom. One is long duration. Long duration is generally said to be an essential ingredient of a custom. This is particularly rule. This is particularly true of custom in municipal law. In municipal law, a custom is required to be ancient and immemorial, but this is not necessary for an international custom. Article 38 of the Statute of the International Court of Justice directs the world court to apply international custom as evidence of a general practice accepted as law. Emphasis is not given on a practice being repeated for a long duration. What is more important is the practice of states accepting the practice concerned as law in the field of international law. Customs have emerged in a short duration. For example, custom relating to sovereignty over airspace and the continental shelf. Uniformity and consistency. The custom should also be uniform and consistent. In the Islam case, the International Court of Justice observed that the rule involved should be in accordance with the constant and uniform usage prescribed by uniform usage practiced by the states in question, and that this usage is the expression of a right pertaining to the state, granting asylum and a duty incumbent on the territorial state. This follows from Article 38 of the Statute of the Court, which refers to international custom as evidence of a general practice accepted as law. According to Henry O. Hudson, the elements necessary are the concordant and recurring action of numerous states in the domain of international relations. The conception of each cases that such action was enjoined by law and the failure of other states to challenge that conception at the time. It may, however, be noted that complete uniformity is not necessary. Nevertheless, there must be substantial uniformity in its judgment of 27 June 1986 in the case concerning military and paramilitary activities in the against Nicaragua while referring occasions violation of the principle of non-intervention. The International Court of Justice observed it is not to be expected that in the practice of states, the application of the rules in a question should have been perfect in the sense that states should have retained with complete consistency from the use of force or from intervention in each other's internal affairs. The court does not consider that for a rule to be established as customary, the corresponding practice must be in absolutely rigorous conformity with the rules. In order to reduce the existence of customary rules, the court deemed it sufficient that the conduct of states should in general be consistent with such rules and that instances of states conduct inconsistent with a given rule should generally have been treated as breaches of that or breaches of that rule, not as indication of the recognition of a new rule. Generality of practice. Although universally or practice is not necessary. The practice should have been generally observed or repeated by numerous states. Opinion juries and necessary according to Article 38 of the Statute of the International Court of Justice. International custom should be the evidence of general practice accepted as law. In the view of Bradley, in applying the forms of evidence in order to establish the existence of an international custom, but is sought for its general recognition among states offers certain practice obligatory. The North Sea continental self-fishing were observed, although the passage of only a short period of time is not necessarily one of itself a bar to the formation of a new rule of customary international law on the basis of what was originally a purely conventional rule. An indispensable requirement would be that within the period in question, short though it might be, state practice, including that of states whose interests are specially affected, should have been more extensive and virtually uniform in the sense of the provision involved and should moreover have occurred in such a way as to show a general recognition that a rule of law or legal obligation is involved. Thus, customary practice, even when it is general and when it is general and consistent, is not customary law unless opinion juris is present. That is to say, unless the practice is recognized as being required by international law, it is this sense of legal obligation as distinguished from motives of fairness, convenience, or morality that underlies customary law. Customary rules of international law have developed as a result of one is diplomatic relations between states, two is practice of international organs, three is state laws, decisions of state courts and state military or administrative practice, and four is duties between states. It is an important matter to see as to how international custom will be applied in international law. There are two leading cases on the point. One is Western Central World, Western, Western Central World Mining Company Limited versus ARM. In this case, a test regarding the general recognition of custom was laid down. The court ruled that for a valid international custom, it is necessary that it should be provided by satisfactory evidence that the custom is of such nature that it had received general consent of the states and no civilized state shall oppose it. In case concerning military and paramilitary activity in and against Nicaragua, the word observed, if a state acts in a way prima facie incompatible with the recognized rule, but defends its conduct by appealing to exceptions or justifications contained within the rule itself, then whether or not the state's conduct is in fact justifiable on that basis, the significance of that attitude is to confirm rather than to weaken the rule. Right of passage over Indian territory case, Portugal versus India. In this case, the International Court of Justice pointed out that when in regard to any matter or practice, two states follow it repeatedly for a long time, it becomes a binding customary rule. The facts of this case deals with the question related to the right of Portugal to send its nationals and military to the Indian territory. Until 1954, Portugal possessed the right of passage to Indian territory, which was in between Daga and Haveli and Daman. The right was, however, subject to control and regulation by India in between October 1953 and July 1954. Certain incidents took place. The relation between India and Portugal worsened. The Portugal worsened, and Portugal claimed that India was exercising excessive control. In July 1954, the people of Naga, which was a Portuguese colony, revolted against the Portuguese government. It naturally in had certain repercussions over the border areas of Indian territory. Consequently, the government of India suspended the right of passage of Portugal over area. India contended that it had become necessary due to the special circumstances that had arisen. Portugal took this matter to the International Court of Justice. The International Court of Justice had to decide whether India was entitled to exercise control over the way and whether Portugal could send its military or armed forces to the passage. The court had also to give its verdict on the point whether India acted contrary to its obligation. It may be noted that the claim of Portugal was based on the Treaty of 1779. The International Court of Justice decided that Portugal was not entitled to send the armed forces through the way which fell within the Indian territory. The court ruled that India did not act contrary to its obligations. The court, however, ruled that the Treaty of 1779 was a valid treaty and Portugal was entitled to get passage through Indian territory in consequence of the provisions of the said treaty. The decision is important insofar as that the International Court of Justice ruled that if under a treaty, a state gets right to passage through the territory of another state, and if it continues for a long time, then it gains the force of law and thereby imposes the obligation upon his state affected to continue to give right of such passage. It may be noted here that on 31st December 1974, a treaty was signed between India and Portugal, wherein the latter recognized the full sovereignty of India over Goa, Daman and Diu, Dadra and Nagar Haveli, as pointed out, as pointed out by Brownell. This case raised as this case raised an issue of bilateral relation, the existence of a local custom in favor of Portugal in respect of territorial enclaves inland from the port of Daman, Damau. In this type of case, resident law is to be varied, and the proponent of the special right has to give affirmative proof of a sense of obligation on the part of the territorial. So when opinio juris is here not to be presumed on the basis of continuous practice and the notion of opinio juris merged into the principles of equio accusenco. It may further be noted that in Aslam case 1950, also the International Court of Justice held that where a local or regional custom is established in such a manner, it has become binding on the other party. Situation when same principle is found in customary law and is also codified in a treaty. This was one of the matter inter alia considered by International Court of Justice in the military and paramilitary activity in and against Nicaragua. In this case, the court was considering the question whether the United States reservation to its acceptance of court's jurisdiction effectively excluded disputes relating to certain multilateral treaties if claims were also based on rules of customary international law incorporated in those treaties. In the instant case, the court found that this identity of content in treaty law and in customary law did not exist in the case of the rule invoked while clarifying the position of law. The word court observed. Even if the customary norm and treaty norm were to have exactly the same content, this would not be a reason for the court to hold that the incorporation of the customary norm not treaty long brushed deep like the customary norm of its applicability as distinct from that of treaty norm. I thank all my brothers and sisters, ladies and gentlemen, students, scholars, teacher, trainer, professor, professor, officer, official, listener, learners, those who are listening, watching YouTube channel creators, I welcome, thank, I thank all respected doctors and directors. I thank all adorable ministers and managers. I thank all honorable advocates and trial administrative advisors. I thank the most honorable Director Modi and all my dear friends. Thank you very much on this last day of this year 2025. And tomorrow we will meet on the 1st January of 2026 with the new thoughts and ideas. Thank you very much. Thank you. Have a nice day. Nice to see all of you. Good morning, all of you. Thank you.